20 minutes. All right. Well, a brief introduction of myself. I'm from China, from Beijing. I dual qualified lawyer, Chinese lawyer, and English solicitor. And I have quite a few roles. One is I'm the managing partner of Zonglun Law Firm, the London office. So Zonglun Law Firm probably is one of the top Chinese firm, having just under 2,000 lawyers, about 15 offices globally. And I'm in charge of our London office. So all the lawyers in London are all dual qualified. And my other role is I'm a general counsel for Hexagon, a global high-tech company specialized in smart city and manufacturing intelligence. I'm dealing with all those cross-border dispute and transaction. So I hope I will be able to view the outcome of arbitration, judicialization, and also mediation from both in-house lawyer, general counsel's perspective, and also a private lawyer's perspective. And certainly, I also have another role teaching in a university, postgraduate student in law in Renmin University, one of the top Chinese university. And so from academic perspective, I hope I can also share my experience. The topic is outcome of those judicialization, arbitration, and mediation. Chronologically, then the starting point is rarely the contract, if this, assuming this is a contractual dispute. So education of at the very early stage of in-house lawyer or those lawyer drafting those agreements is extremely important because arbitration, certainly apart from this judicial decision from court, is a default position. Otherwise, if you don't have this arbitration clause or mediation clause within the agreement, well then those arbitration or mediation will certainly does not come into play when there is a dispute. Therefore, chronologically, whenever there is an opportunity as a litigator or as a private lawyer, then talk to your client, teach or educate your clients on the differences between mediation, judicialization, and arbitration is equally important, so that eventually you will be able to explore what you believe to be more efficient in terms of those choices. So that's a chronological perspective. And in terms of the mechanism, certainly by definition, judicialization or arbitration decision is a decision by a third party. And certainly whatever those parties in dispute will have their own desire or wishes, eventually the decision will be made by either a judge or an arbitrator, either appointed by you or selected by the chairman or actually by the procedure, judicial procedure, unless it is arbitration, mediation. Mediation, again, by definition, certainly is a new agreement between those disputed parties. And as a general counsel and also private lawyer, I have always recommend mediation if all possible, because that's the mechanism that you will have a positive, active, proactive role that you can play. And if you cannot reach an agreement, new agreement between the two parties and relying on a third party, either a judge or arbitrator, whatever the outcome is, then it's highly unlikely both parties will be happy anyway. So my recommendation, both as a private lawyer and also in as general counsel, is always trying to have this mediation if all possible. And then for mediation purposes, then if I can, then from Chinese perspective, mediation is not a compulsory and it's not a popular mechanism now for dealing with commercial dispute. But then again, on the other hand, it will be an automatic procedure whenever there is a judicial involvement. It will be guided and participated by the judge. So any mediation within the litigation or within judicial proceedings will be directly enforceable because of the involvement of the Chinese judicial system. And then from English perspective, certainly it's more of a choice. and then it's more of a new agreement between two parties. But because of the fact that you have reached this new agreement by mutual will, and hopefully it will be more easily enforceable purely because of the fact this is a new agreement. Otherwise, you will proceed to either arbitration or litigation. That's from mechanism perspective, and then because the subject matter is the outcome or efficiency for arbitration, mediation, or judicial decision. From General Counsel's perspective, then whatever the efficiency or outcome, that has to be business orientated. It has to be by reference to the business needs. So talking to client is the extremely important part. What your client want to achieve. Will that be, because even though from a realistic and perspective, practical perspective, enforcement is always the ultimate importance in any dispute. Then if this is a cross-border dispute, for instance, if it does involve Chinese elements, and then judicial decision is not directly enforceable in China anyway, we don't have any judicial arrangement with any third party or with any other country, including European Union or the American or any other part of the world. So if you want to have a decision directly enforceable, then it has to be either by way of arbitration, because we are party to the Paris Convention, and or mediation, because that's a new agreement. So that's one of the key elements. Talk to your client and to understand what your clients really want to achieve, because whatever the outcome you believe to be good from judicial or from legal perspective does not necessarily meet your client's need. If relationship is the most paramount importance to your client, then mediation will be probably the only choice if you do not want to damage that relation or continuous business relationship. And then if it is for enforcement purposes with these cross-border elements, and then the defendant is based in China and most of the asset, enforceable asset is in China, then judicial decision will not help anyway, because you will not need to have that virtually any foreign judicial decision retrialed within the Chinese system. So having an arbitration and certainly having arbitration clause embedded in the original agreement will be extremely important. So my view is really the starting point is certainly the agreement, and then in terms of outcome, it will be your client's decision. Because my colleague Franz has mentioned about this added value as a general counsel, and keep on being impressed by the business leader to add value to the business. And then whenever there is a dispute, I will always try to find out the most relevant business from the most relevant business team as to what their objective is. If this, as I mentioned, relationship not being damaged, then certainly mediation will be always recommended. But then if that is impossible, and then enforcement is the ultimate purposes, then arbitration or judicial decision depends on the jurisdiction and whether there will be any cross-border perspective. So my conclusion really is if there has been, unfortunately, there has been some dispute, then the starting point is talking to client, taking instruction, clear instruction as to what is their commercial business objective is. And then look into the agreement, and hopefully at the time of the dispute, the most desirable solution, either arbitration or mediation or judicial, certainly that's by default, has been embedded into the agreement by your effort or endeavor at the early stage, educating the lawyer or the in-house counsel or even your clients that those clause is available for you to rely upon. If there's no arbitration clause, well, bad luck. Even though that may be the best solution, then it is not available. You have to probably go through judicial. That's the view I would like to share. And then if I have to mention about the differences between the Chinese or say English jurisdiction, then we do have a lot of differences as a continental legal system. we don't have case law. And all those decisions are just persuasive, and only decision by the Supreme Court is binding on the lower court. But then that's equally, when I say binding, it's just persuasive. It's not binding as such. It will be all the rule of law is construed by the purpose, ultimate purpose. Therefore, say in China, if you have a dispute with the tax authority, then any litigation doesn't seem to help if you try to argue on a technical point of law. Because the ultimate purpose, then the Chinese judge is always taking the view, what is the ultimate purpose of the tax law? It's taking tax. And whatever design, your mechanism, or whatever structure you have put in place, if the ultimate purpose is to avoid or unlegitimately reduce the tax, that would not be effective. And then, so that's one of the differences. On the other hand, probably because of the facts that even though we have this contempt of court and prejudice to justice, then any witness statement will not be treated seriously, because it will be assumed in commercial litigation in China that anyone giving witness on behalf of the claimant, especially if you are an employee of a company, then they will assume that you are giving witness statement on behalf of your company. And so it's more of physical evidence, which is carrying more weight. We don't have that similar like cross-examination, chief examination system. Therefore, you will always stress or give more emphasis on physical evidence, such as documentary evidence, or even those expert report, which will carry a lot of weight, and the judge can rely on those. But then if it's a simple witness statement, will always be conflicting witness statement, on one hand from the plaintiff or the claimants, on the other hand from the defendants. Therefore, that's if you are dealing with any Chinese-related dispute, and if it's in China, then taking into account the approach and the attitude and the difference in culture, that will always be helpful eventually to a client and to raise your own reputation, and eventually to help the general counsel so that you can maintain a better and continuous relationship with this increased number of general counsel from private practice, at least in China, in England. Then, because you are talking to lawyers, you are talking to an experienced lawyer, and then even though you are a litigator, then do take into account that those general counsel, in-house lawyers have similar experience with yourself. Therefore, to be creative and being able to add value and being able to help the general counsel and the in-house lawyer equally will be more important than anything else. Then probably that's what I would like to share with you, and hope that will be helpful. Thank you.